We're jumping right into the ultimate high-wire act in the Philippine justice system, how courts manage to balance the relentless pursuit of the truth with the absolute need to protect our constitutional rights. It's an incredibly delicate dance, and we are going to explore exactly how the highest courts manage it by looking at some truly landmark cases. Okay, let's quickly hit today's roadmap. We'll be looking at the pursuit of truth, diving deep into the DNA dilemma, pushing the limits of privacy, uncovering the privilege of secrets, examining technology in the courtroom, and wrapping up with the ultimate standard. Starting right off with Section 1, the pursuit of truth, and balancing those scales of justice. We have to start here, because this is the absolute core of the judicial system. Every single rule, every objection you hear, every piece of evidence presented serves this one ultimate goal. As the Supreme Court noted in Nuez versus Cruzapao, the administration of justice is literally a sacred task. They demand the absolute highest sense of honesty from anyone involved. Think about it. When court personnel peddle influence, it completely shatters the public trust. Finding the truth requires a system that is totally uncompromised. But here's where it gets really interesting. Courts are constantly caught in what we call a trilemma when deciding what evidence is actually admissible. They desperately want the truth, right? But they also have to protect the adversarial process, and above all else, they cannot violate our constitutional rights. So how on earth do they balance these three competing forces? That brings us to Section 2, the DNA dilemma, featuring our main focus for today, the landmark case of Herrera versus Alba from 2005. This was a deeply emotional, super high-stakes paternity dispute between a mother demanding a DNA test and a putative father aggressively resisting it. And this is the exact legal dilemma the Supreme Court had to untangle. The father claimed that forcing him to give a genetic sample was unconstitutional. He argued it violated his fundamental right against self-incrimination. It's a brilliant question when you think about it. Does handing over your DNA essentially count as testifying against yourself? To understand why this case is such a game changer, look at how wild things used to be. Before modern science, parties had to rely on these four procedural aspects to build a traditional paternity action. They'd build a prima facie case with letters, rely on legal presumptions, or use incredibly subjective things like physical resemblance. Literally, imagine a court trying to decide paternity just by squinting at a child's face and comparing it to the alleged father. But then, science steps in. The Supreme Court established the Vallejo standard threshold. If a DNA test establishes a 99.9% or higher probability, boom, it creates a refutable presumption of paternity. Science gives us near-perfect accuracy, totally replacing those old subjective guesses with hard biological facts. So back to the constitutional question. The court hit the nail on the head here, ruling that getting a tiny DNA sample relies objectively on science, not forced testimony. The right against self-incrimination applies only to testimonial compulsion, meaning nobody can force you to speak or write a confession. But your physical biology? That's admissible. In the Herrera versus Alba trilemma, the pursuit of truth prevailed without breaking the Constitution, a total win for the balancing act. Let's shift gears to Section 3. The limits of privacy. Looking at the case of People versus Marti, we're expanding our lens to see how this balancing act applies to physical searches and seizures. Imagine this scenario. You send a package, and the courier gets suspicious, opens it up, and finds something highly illegal. Have your constitutional rights against unreasonable search and seizure been violated? Well, we have to break down an absolutely crucial legal distinction here. The Bill of Rights is a wall of protection against the government. It protects you from state action. But if a private citizen, like, say, a curious proprietor of a shipping company, conducts an inspection totally on their own initiative, those constitutional protections simply do not apply. And that's exactly what happened in the Marty case. A man tried to ship 4 gift-wrap packages to Switzerland. He claimed they were just books and cigars, but the proprietor smelled a peculiar odor. Following standard procedure, he opened them himself and found dried marijuana leaves hidden inside. He only called the NBI after he made the discovery. Because the private proprietor acted entirely on his own without any police interference, the evidence was completely admissible. The constitutional shield, as it turns out, has very specific boundaries. Moving on to Section 4, the privilege of secrets. Let's step into the corporate world with PCGG versus Sandigan Babayan and the ACRR lawyers to see how the trilemma handles confidential secrets. In a massive effort to recover alleged ill-gotten wealth, the government tried to force lawyers to reveal the identities of their anonymous clients.
This was a massive test of the absolute limits of attorney-client privilege. The state is demanding the truth, but the lawyers are arguing they have a sacred duty to protect their clients' secrets. Who wins?
While protecting the adversary system definitely requires broad privilege so clients can actually trust their counsel, this powerful quote from the decision really grounds us. A lawyer is not a gun for hire. The attorney-client relationship is vital, but it absolutely cannot be used as a shield to concoct or commit crimes.
The general rule is that client identity is privileged, right? But courts will pierce that veil in a few specific scenarios. If the lawyer is acting as a co-conspirator, or if revealing the name provides the exact necessary link to build a criminal case. But, and this is a big but, the court also noted this privilege must be narrowly constructed. We can't just allow fishing expeditions by lazy prosecutors trying to force lawyers to do their investigative work for them. Again, it's all about that delicate balance.
All right, Section 5, Technology in the Courtroom. Let's look at how the Balancing Act handles something incredibly practical in MCC Industrial Sales Corp.
In this case, a major commercial dispute hinged entirely on faxed steel orders. The Supreme Court had to interpret the Electronic Commerce Act and answer a seemingly simple question. Is a slightly blurry fax printout considered an original electronic data message under the law?
The answer? A hard no. Facsimile printouts are not electronic data messages. A fax is essentially just a paper copy zapped over a phone line. So faxes do not get any special digital privileges. They are classified simply as secondary evidence.
What does that mean in practice? It means lawyers can't just wave a fax in the air and scream proof. They have to go through rigorous steps. They must prove the original document actually existed, prove it was lost or destroyed without bad faith, and show a diligent, bona fide search was made to find it. Only after jumping through all those traditional hoops will a court even look at a fax. The pursuit of truth demands reliability, for sure.
Finally, we arrive at Section 6, the ultimate standard, looking at people versus commod. Because at the end of the day, how is all this evidence, whether it's DNA, seized marijuana, or faxes, weighed against the highest right of all? Even with the most advanced science, the state bears the absolute, unwavering burden of proving guilt. The prosecution must prove the elements of the crime with moral certainty. If they fail, that constitutional presumption of innocence stands strong, and the accused walks. The balance must remain perfectly impartial. So, I leave you with this provocative thought to ponder. We all want the truth, absolutely, but we also demand constitutional protection. Are we comfortable with the fact that sometimes protecting the system means the truth is legally suppressed? It is the great trilemma of justice. I highly encourage you to look deeper into how our legal system elegantly and rigorously protects us all. Thanks for joining me on this explainer, and keep questioning the balance.